Chair thanks the gentlelady. Gentlelady yields back to the gentleman from Texas. Recognized for questions.
I thank both gentlemen for being here and testifying. Just a few things. I know we're trying to move along in the interest of time. I would just, since we had the exchange with the gentleman from Kentucky, just stipulate for the record, I assume the gentleman from Texas, or from both gentlemen, agree in broad terms, the findings are laying out first that the United States and Israel are not parties to the Rome Statute or members of the ICC. And so therefore that raises legitimacy or jurisdiction over the United States or Israel. That's one primary, I think, an important point. Lays out the extent to which the prosecutor, Mr. Khan, announced arrest warrant applications for the Prime Minister, which I don't believe is disputed, and applications, to be clear, because some people get that wrong in the press, but for the Prime Minister and the Minister of Defense, Mr. Gallant, and does say that those should be condemned. I think, which I certainly agree with respect to condemnation. I believe there's bipartisan agreement on that in broad terms. And then there's a couple of other things in here which people can see. And the ICC's actions against Israel are illegitimate and baseless, which, again, consistent with the point here about the ICC itself, which I would argue is consistent with what the gentleman from Kentucky was saying, but I'll let him judge that for himself. But just for clarifying, since we had a discussion about it, I wanted to make sure people understood why those findings existed. I would ask the gentleman, Mr. Crow, respectfully, having served, do you believe that the ICC should be able to go after an American serviceman?
I do not.
Good. On that, we have agreement. Do you believe that the ICC should be able to go after one of our allies?
Depends on the allies and the circumstances. Every individual circumstance is different. I'm assuming you're talking about this instance of Israel. I do have concerns of jurisdictional issues, and those are concerns that I think are worth debating. So the question is not, in my view, the concerns about jurisdictional issues, which have multiple components, right? There's the component of whether or not you're a party, but then there's also the implication that the ICC has made here, the assumption that the ICC has made here that the West Bank and Gaza are basically a state actor, part of a Palestine, which of course is something that should be debated as well. So those are debates that are worth having. The issue is, what is the remedy? And the remedy should not be, in this instance, sanctions, because I think that the blowback and the risk to the United States of this approach are severe.
Appreciate that. I'd ask my colleague from Texas about the importance of sanctions here. I think we've had some discussion here about the precedent setting, and the gentleman from Texas discussed the precedent setting, and the extent to which we allow the ICC, which we do not, the jurisdictional question has been discussed here, which we're not a party to, that you have a court out there that could be turned on, and it's not without precedent, that they try to come after and target American service members. And when the ICC takes this kind of a step, which has been condemned pretty roundly by members of both sides of the aisle, executive branch and legislative, and this is now I'm going to assert my position on it, that is deserving of significant rebuke, and that without something with teeth, that you're not going to limit the extent to which the ICC feels empowered and permitted to engage in this sort of activity in the future, including directed towards our own service members or our own Americans engaged in this kind of activity. And so I would ask the gentleman from Texas if he agrees with that and underscores the importance of timing, that stopping this before it moves very far down the track is critically important because of the unbelievably egregious nature of the ICC announcing the intent to issue warrants against the Prime Minister of Israel. I just want to say that out loud, and the Defense Minister of Israel, and that merits the strongest possible rebuke by the United States, and therefore setting up a construct, which this is designed to do, not haphazardly, but in direct consultation and working, by the way, across the aisle. Not that we reached agreement on every point, as is evidenced here in the debate, but reaching the ability to use a model, in this case, CATSA. I mean, we took an existing framework that had been passed and passed on a bipartisan basis, applied that framework, and that is literally the basis of the construct for how the president could grant some waiver by coming to Congress and presenting it on a case-by-case basis. We tried to use that existing model. But I think at the end of the day, it's just a question of sanctions or no sanctions. I mean, we can debate some of the specifics. And like the gentleman raises points about the extent to which the language allows its extension to countries that are supporting the ICC, allies are supporting the ICC, and family members. The purpose of it was to, in fact, put teeth into it. It was to say that if you're a judge and you are targeting Americans, or you're targeting our friend, the Prime Minister of Israel, yeah, maybe your kid who wants to roll over here and go to Harvard, maybe that kid shouldn't be able to do that. I think these were questions that I think we thought through and thought were important to address. What if the gentleman from Texas would have thoughts on that matter, and then I'll allow the
It's vitally
Mr. Crow.
important we kill the snake while it's young in the nest.
Yeah.
That's the analogy. And that's, I believe we talked a lot about alliances here. I believe that our Western European allies, when they realized they could be next, they might join us. And frankly, there is a national security waiver in this bill, if I remember right, Mr. Roy. So we can actually have waivers for this bill should it be in the national interest of the United States. So absolutely, you are exactly right, because I've heard several comments here about undermining our alliances, damaging our reputation in the world. Folks, I don't know how much our reputation in the world can get any lower. There's an old saying about whales in the ocean, but we've got to do something to reestablish our reputation in the world. And I yield back.
I assume the gentleman both. I'll let the gentleman respond. Mr. Crow, did you want to respond or
Sure.
time.
I vehemently disagree with this notion that our reputation worldwide is couldn't be lower. So what does it matter? I think our reputation matters a lot. I think our reputation is very strong. We certainly have issues like every country that we need to address. But as I said in my opening, this is not a race to the bottom, nor should it be. And we work with the ICC all of the time when it's in our vital national interests, right? So if we're going to be about rules of law, if we're going to be about consistency, if we're going to be about supporting international institutions, then the thing about rule of law is you either support it all the time or you don't. You can't support it some of the time, or you can only support it when you agree with it. And why I raised that last point is because, and I raised this also in my opening, you all supported the Ukraine War Crimes Deterrence and Accountability Act, right? Which supports the ICC investigations against Russia, when Russia is not a party. So, to stand here now and say, the jurisdictional issue is the predominant one doesn't really fit with the history there. Then the last thing I'll say is the facts of specific instances are really important, because one of the primary things to look at when you look at whether any tribunal is appropriate for a given instance is the issue of whether or not there is an internal domestic legal process that can actually handle the issue within a country, right? And that's one of the reasons why we've all supported prosecutions and actions against Russia, because of course there is no viable internal process there. So we have to look at every individual circumstance on its own merits.
Mr. Roy, if I could respond to the Ukraine comment. Did not Ukraine authorize action inside Ukraine?
Well, my recollection of that bill is that it did not specifically mention the ICC. I understand the gentleman's point, but I think what's important here is the threshold question, and the gentleman responded to it honestly, and I appreciate that when posed with the question whether the ICC, if it went after our own service members, the gentleman said he would not support that, nor would I, nor do I think any of us should. And I think the question here is whether, when we have a close ally and you have the ICC and you're empowering the ICC, right? If you kind of sit back and allow the ICC to engage in that activity against a non-party state, our ally, engaged in defense, then what precedent does that set? Right? What precedent does that set to have an international tribunal to which we're not a party, to which our allies are not a party, having a judge issue warrants against the prime minister of somebody that we're relying on to help defend us in the Middle East, in theater, engage in active conflict, dealing with the fact that they had their own individuals who were targeted and killed October 7th of the most horrific crimes possible, dealing with the constant affront of thousands of missiles being shot at them from Hamas. And we can debate, and I'll take the gentleman at his word about the relative ratio, rate of casualties and with respect to civilians in Gaza. I've certainly seen reports that would suggest that the numbers are actually fairly impressive in terms of what they've been trying to do to target and avoid hitting civilians while still trying to carry out the activity of taking out Hamas. And I think here the question is whether the United States of America stands alongside Israel in trying to stop Hamas from continuing to do what they're doing, which is targeting Israel, to eradicate Israel, undermine Israel, our ally, our stated ally. And that, I think, is what is right before us right now. And when we have the extent to which the ICC effectively broke its own rules under the Rome Statute of the ICC by permitting the recognition of the state of Palestine, when in fact it's only countries can be part of the ICC. Understanding the debate that's ongoing about that, these are the issues that I think are significant and at play. I would also note that former President Trump, when he engaged in, and not to politicize it in that way, but we're bringing up the issues that are important, that the sanctions against the ICC worked, right? And that the United States taking positions like that matter. And this is what it boils down to. Bottom line here is we have a significant number of our Democratic colleagues who recognize what the ICC did here was horrific and needs actual teeth in response. We hope and believe that those Democratic colleagues will join with us in saying the United States should speak with a consistent, loud voice and sanction the ICC for what they're doing to our ally Israel. And unfortunately, the White House seems unwilling to want to take that step for political reasons, whatever reasons we want to ascribe to the White House. And I'll only say that I had a significant, I'm not going to talk about private conversations, but I had a large number of conversations with Democrat colleagues across the leadership spectrum and rank and file about this bill and this issue. And there's a lot of interest in wanting to work on it. A lot of it, and working on this construct, a construct that is not plucked out of thin air, isn't just made up, is modeled after existing statutes that we have agreed to. Literally take the statute right out of it and boom, put it in here and apply it. I think this is a simple question, and I think that's what's being laid bare here. Should we sanction the ICC or not? I think that is the question that is before us.
Mr. Can I comment on that?
I know we got votes.
I think there's a question of the underlying concerns of which there is broad bipartisan concern about certain elements of this case versus what's the appropriate remedy.
Fair.
And the White House did come out and release a statement of administration policy just a couple of hours ago.
Saw it.
Where they said they're willing to work with Congress to figure out the appropriate remedy. So people are coming to the table and they're saying, all right, we have concerns. We have bipartisan concern about this. Let's figure this out. But the remedy can't possibly be we're going to put ourselves into a position of sanctioning 36 of our NATO and major non-NATO allies, sanctioning children of officials of the ICC, and also directly undermining all of the cooperation that is in our interests that the ICC is doing, that we are assisting in because it serves our national security interests. That couldn't possibly be the remedy, and that's my point. I think there's a lot of people who are willing to step up to the plate and say, you know what, let's take a step back. Let's go through the process. Let's have a hearing. Let's think about the secondary and the tertiary and the unintended consequences of this. Let's take a breath and figure out a path that doesn't jeopardize our own national security and our own interests in the manner in which this bill, because of the way it's drafted, does.
Mr. Self, do you want to speak to that?
I would just say, Mr. Roy, I appreciate your leadership getting movement on this, because I think he's right. There's movement, and I appreciate this bill doing that. Thank you.
I appreciate it, gentleman from Texas. I would just note that since the ICC's founding, which has now been over 20 years ago, every United States administration, both sides of the aisle, both parties, have refused to join the court, recognizing the concerns with its politicization and misuse. We are seeing a direct misuse directly right in front of us. As this Secretary of State Anthony Blinken said, quote, "We maintain our longstanding objection to the court's efforts to assert jurisdiction over personnel of non-state parties such as the United States and Israel. We're seeing them engage in it as we speak. It is incumbent upon Congress to act, particularly when the White House refuses to." With that, I yield back to the chairman.
Gentleman yields back, Chair. Thanks.